You see, legitimate expectation is the bedrock of justice and fairness. So a person who takes the right foot should not fall into a pit unless he has committed an offense, which is very well known. So a person who takes the right foot is legitimately expecting to pull the left foot again also, because we live on legitimate expectation. So rule of law is the basis of is based on legitimate expectation. So I can see many of you are very young. You people, I was there the day Amin was overthrown. I think we were on holidays, the long vac of 1971 in January. We were on holidays. I was there. So you people, some of these things you see today happening, I saw them myself. I saw them, and I was at the university, I think in my second year or third year. I think my second year, I was at university, 1986, when the NRA rebels came. They came and they imposed the peace in Kampala, and they were all very happy. You see, they really ushered in peace. It's as if they brought it in a bag and ushered it there. And peace was imposed. You know, life had been very, 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 very dangerous at the time. I remember one day I was walking from Wandage Market, and I just survived a bullet from within Makere University. So those were very bad times. So these people, when they came, they really solved a very big problem. But you people, you are very young. I can see that things are going back to where we came from. If we don't stand up and demand that we need the rule of law, we shall go back to where we came from. And it's going to be very, very difficult to come back. Legitimate expectation should be for us all. As long as a person has not committed an offense, in other words, for that person to become liable to be indebted to society, then he has no debt to pay under the criminal law. So you people, I'm encouraging everybody of you here present, wherever you are, we should really look to strengthen the rule of law. Okay, I've been down with a stroke, and I saw what happened in 2001, because everything was online. I saw blood on the streets during that election. It is very, very, very sad. I think we should not go back to that. Everybody should, either through prayer or through whatever a person can do, we should do something in order for us to have rule of law again. It's very unfortunate that the people who ushered in peace are also bouncing it anyway. Ushers are also bouncers anyway. Well, I was reading online, people being abducted. Those are the things which were really condemned by people who came in 1986. People being abducted. You people, we need to do something. Everybody in his own right should do something to make sure that we don't go back to where we came from. It was very bad. It was very sad. Okay, the cases I've handled, there's one case which has not been mentioned. There's the case of Karugaba versus Attorney General. The case of Karugaba was Attorney General in 2000. In the year 2000, there was an Irish priest, a missionary in Karamoja. He was called Father Francis Otole. Father Francis Otole was robbed of some money by some soldiers, UPDF soldiers. So, and they robbed him and killed him. Then in Karamoja there was no war at the time, but they wanted the government had an intention to pacify the place because it was because of cattle rustling and so on and so forth. There was a lot of insecurity. Government had put their soldiers to pacify the place. So Father Francis Otolle was robbed and killed by these soldiers. Then Major Wamala, Major Semakula, at the time, I don't know where he is today, announced that the soldiers have been arrested and they would be tried and executed the following day. That came out in the Sunday dailies of the. I don't know. I don't remember the month, but that's what Semakula said. So those soldiers were tried. I think there were 2. They were tried, convicted, and executed immediately. And then, for us as lawyers, we had to think very hard. Was this execution constitutional? So we realized that the field court marshal had the jurisdiction to do whatever they did, but the problem is, could they sentence a person? Can a field court marshal act in a place where there is no war? Because that place had not been gazetted as a war area. So we went to the Constitutional Court. The Constitutional Court said that the Constitution in Article 22 says that you cannot execute a person after conviction unless that person has been given an opportunity to appeal up to the Supreme Court. So the Constitutional Court said that it was wrong, the execution was wrongful. So we started these things some time back. When we filed that petition, the Uganda Law Society joined it. So it became Karugaba together with Uganda Law Society. That was in 2002. But the Constitutional Court said that everybody who exercises a judicial authority in the country is exercising it on behalf of the people, because judicial authority belongs to the people in the Constitution. As long as you have that delegated authority to exercise it, you must exercise it within the constitutional bounds, which include according the accused person the right to a fair trial. So the Constitutional Court emphasizes the fair trial. Okay. There are several other cases. Then, I think in 2007, okay, let me say this also. How did the court martial start trying civilians? In my opinion, what happened is this. In the general election of 2001, I think many of you were very, very young. For us, I was already practicing advocate. So I saw what happened. There was a lot of thuggery. Actually, that election was so bad. There was so much thuggery. People were using guns recklessly in that election. And if you go back and read the findings of the Supreme Court in that election, in the petition, you'll find that all those things were proved, that there was so much thuggery. So now these thugs who were robbing people became a problem to government because they had been given a kind of license. They thought they can go ahead and continue getting wealthy by robbing people. So how do you manage such a crisis? So they decided that the constitutional, that the field marshal, that the court martial shall try civilians. it was really for managing a crisis that the state had created itself. I was in court. I represented many people in 2001 when were the first chairperson was Mr. General Tumwine. General Edith Tumwine was the first chairperson, and he said some of the cases, he dismissed some of the cases and said they were not fit to go to him. I remember I was representing, there's one of the people I was representing had been a building at a certain site, and the owner of the site alleged that a doorbell had gone missing. So this young man was beaten up and tortured and brought to court-martial and charged with robbery. So Tumwine dismissed those cases. He transferred them to Uganda Road Court. He said they did not fit to be tried in that court. So the thing is this: that court can be abused because there's no DPP, there's nobody to sieve out the chaff. The court can be abused. And let me tell you people, a person is not supposed to lose his liberty. A person is supposed to have his liberty, in other words, to be free to move. But the Constitution says if you commit an offense and the court has tried, you are in court, you can lose your liberty. So once the legal process is set into motion, the legal process should be set into motion for a person who really, there is a likelihood that that person has committed an offense. Because even the Constitution says there must be a likelihood that a person has committed an offense. That likelihood should not be through conjecture. It should not be through a whim. It should be through real. That the suspicion should be reasonable. Should have been arrived upon through investigations. Now the problem with the court-martial, there are no investigations. Okay, the military does its own investigation, we don't know. But then, for me, the cases I've handled in that court, really, like that case of the doorbell. There are so many such cases that have ended. Then, in 2006, 2007, actually, the Supreme Court, in the late judgment of Justice Mulenga, said that a person who has nothing to do with the military should not be tried in military courts. So what the military did, all the people they had arrested, they would say, "We have been found with a weapon, ordinarily the monopoly of the UPDF." They amended the charges and said so and so is being charged with being found in a possession with a weapon, ordinarily the monopoly of the UPDF. Now the problem with that is there's a problem with that one because you see, there was one case of Hadija Namgero. Hadija Namgero was a paternal aunt of Salim Muhammad. Now Hadija Namgero came to me seeking a representation of her son, of her nephew. Salim Muhammad had been found with a star pistol in Makinde there, and charged with being found with a weapon being a monopoly of the UPDF. Now a star pistol, how can you say it is the UPDF has the monopoly of the star pistol? When you read the Firearms Act, when you read the Firearms Act makes most of those weapons are licensable, including SMG. All those are licensable weapons. Of course, there are weapons which are not licensable, like for example, a tank. If you have a tank, and that is one is really the monopoly of the defense force. Or grenades or that kind of thing. That one should, on the face of it, is ordinarily the monopoly of the UPDF. Go to the court-martial and be tried there. But really, it is very unfair to try civilians in court-martial, because that court has been abused, and we need to do something about it. And you see, for example, if they say that you have been charged with aiding and abetting the commission of a service offense by a person subject to military law, even that one is a problem, because you see, aiding and abetting is what? Is an ingredient of an offense which must be proved through trial. If it is an ingredient of an offense to be proved through trial, for example, at one point, after the prosecution has presented its case, the court must rule whether there's a case to answer or not. How about if the court says that actually it's not true, that there's no evidence that you aided and abetted this crime? That one is a problem. A person shall have already gone through, shall already have lost his liberty and a legal process that is unlawful. So you people, I'm calling upon everybody of you, whether through prayer or whatever that can be done. And let me tell you people, I was here in 2003 when the Constituent Assembly statute was being debated in the NRC. Was it NRC? It was not Parliament, because Museveni was still the chairperson. It was the NRC. So the Constituent Assembly spent more than 9 days, actually spent the longest time on the chapter on fair trial, because there was so much to be said. For example, there was the Public Order and Security Act. You people, you didn't know about it. The Public Order and Security Act gave the power to the Minister of Internal Affairs to think, if he thinks that so and so has committed an offense, that person can be detained. The Public Order and Security Act was eventually repealed by this very government, because they said it was a very unfair law, because it meant that people are being taken to court without trial. Then lastly, I've told you of the case of Hadija Namgerwa. Salim Muhammad was charged with being found in possession of a star pistol. Now the star pistol, eventually, the Supreme Court said that if you are found in possession with a weapon ordinarily the monopoly of the UPDF, then you are supposed to be tried there. So when we were leaving court, I saw one of the judges, I can't mention his name now. One of the judges had his pistol from his pocket fall down. And to me, it looked like a star pistol, but anyway, he was a judge. I don't know if he had that pistol even in court, but you can see the unfairness of some of these things. You know, I have a lot to say, but I think I've said enough. Thank you very much, Radical Nuba.